Nuremberg, November 1945. The Second World War is over, and 22 senior Nazis are on trial for their lives. Despite the horrors they have perpetrated, these once powerful men now face a court intent on giving them a fair trial. The US Chief Prosecutor, Robert H. Jackson, outlines the Allies' plan.
That four great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason.
In their pursuit of justice, the Allies were about to embark on a bold legal experiment that would echo through history. The horror that was World War II was unprecedented in human history. Tens of millions died on the battlefield, and in appalling atrocities. But out of the chaos and suffering, the victorious Allies sought justice for those who had been wronged, in the hope of preventing such crimes from ever being committed again. In pursuing the guilty and exposing the truth, who would be held to account? And who would escape justice? Compromised by politics and the desire for revenge, the pursuit of justice was imperfect. Yet these trials redefined international law and shaped the modern world. This is World War II, History on Trial.
This is the building in Nuremberg where 20 top Nazis are being tried for many crimes.
The International Military Tribunal, known to history as the Nuremberg Trial, was held by the four Allied nations occupying Germany in the immediate aftermath of the war. In the wake of an unprecedented cataclysm, the tribunal sought to do something new. Building on rules of war that had been evolving for centuries, they sought to solidify a system of laws to protect the peace and to punish the guilty.
That the indictment shall now be read.
If we kind of go back in history, we can see there's always been some understanding that some kind of norms or some kind of laws should control warfare. Big thinkers from, let's say, the 17th century believed it's wrong, for example, to engage in assassination in a time of war. There had, for example, been conventions in The Hague in 1899 and again in 1907, which had codified certain understandings of war crimes.
The agreements reached in The Hague sought to limit the horrors of modern warfare by restricting certain types of weapons, protecting enemy prisoners and civilians, and mapping out an honorable, almost gentlemanly way to fight wars.
The problem with all this was what kind of tribunal existed for the purposes of bringing people who engaged in bad acts during war to trial.
The first great test of these conventions was the First World War. This was a truly modern war that swallowed not just armies, but civilians as well, destroying millions of lives. Both sides committed war crimes. German troops massacred Belgian civilians. A British naval blockade starved hundreds of thousands of Germans. And in a chilling forerunner of the Holocaust, the Ottomans used concentration camps and death marches to murder up to 1.5 million Armenians. After the war ended, the victorious Allies met at Versailles to negotiate a peace settlement and set out a process for the prosecution of war crimes.
What the peace treaty says is that persons who will be prosecuted will be in front of military tribunals, with different judges from different allied countries sitting together. The Versailles Peace Treaty in this regard is unique because it really is the first time that a reflection is going to really end up in a concrete text with concrete articles dealing with this question.
The Versailles Treaty was deeply unpopular in Germany, and the government refused to extradite their soldiers and sailors, choosing instead to prosecute their own in a series of trials held in the city of Leipzig. This did not go down well with the Allies.
They found that the trials or ended up in acquittals, which was unacceptable, not only for the governments, but also for the public opinion.
This first attempt at bringing war criminals to justice had been a dismal failure. The crimes of the First World War would largely go unpunished.
Well, the fact that after the First World War there was no prosecution of the war crimes that had been committed did have certainly an influence on the Second World War and the cruelty of the war. I mean, Hitler himself said at one point, "Who talks about the Armenians today?"
A chilling forerunner for what was to come as, barely 20 years after the end of the First, Hitler plunged the world into a Second World War. On the 1st of September 1939, Hitler embarked on his own genocidal war. Beginning in Poland, the German army and SS conducted a brutal, racialized war that killed millions of civilians, including over 6 million Jews.
The atrocities of World War II were exponentially worse than World War I was, and World War I was pretty awful.
An unprecedented global war demanded an unprecedented response.
The fact that it was the second global conflict in less than half a century left the architects of the post-war order feeling that something had to be done differently to try to achieve peace once and for all.
It became clear at the latest in 1943 that one could not sort of ignore these crimes after the end of the hostilities. And they drafted a declaration saying that after the end of the war, there will be criminal prosecution.
So very early on, they start to frame the general framework of what post-war justice might look like. There is a necessity to imagine a new legal context, a new legal framework, a new legal response.
At Moscow in 1943, the Allies decided to establish a joint military tribunal to punish German war crimes.
We will continue hand in hand like comrades and brothers until every vestige of the Nazi regime has been beaten into the ground.
But how would justice best be served?
One thing we need to remember, though, was there was by no means universal agreement on that. Most famously, Winston Churchill wanted to summarily execute something like 200 of the leading members of the Nazi Party. That was his solution to the problem. There were some elements within the United States cabinet who felt much the same way.
Amongst the Allied leadership, a desire for justice was often mixed with a desire for vengeance.
We believe that the Nazis and the fascists
have asked for it, and they're going to get it.
But some held on to the belief that the rule of law should be applied to even the most senior and notorious Nazis. The chief advocate of this position was Supreme Court Associate Judge Robert H. Jackson.
And he said clearly that you can do with these criminals whatever you want, but you have to have a proper trial. This is the only way you have the chance of changing the law and being persuasive to the entire world and also to the German people.
Jackson hoped that the trial of the Nazis would demonstrate the moral superiority of the Allied cause.
The Allies are adamant that this be a real criminal trial. This is not just a kind of a drumhead court-martial. This is not just a show trial. This is not just an excuse to hang a bunch of Nazis.
The Allies were about to embark on a high-risk strategy.
If you were to have a proper trial, you have to presume that every accused is innocent before you prove beyond a reasonable doubt his guilt. And if you don't have enough evidence, what do? You have to acquit, and that would be a horrible scenario.
For justice to succeed, the trials would need to persuade the world that this was more than merely victor's vengeance, more than merely show trials. They would need to be grounded in law, and their judgments would need to be unassailable. In London in June 1945, 1 month after the end of the war in Europe, the Allies met to form the International Military Tribunal. This trial would not just be for show. It would represent a step forward for international law and for human civilization. Jackson pointed out, "What we propose is to punish acts which have been regarded as criminal since the time of Cain, and have been so written in every civilized code." Representatives of the French, British, US, and Soviet governments outlined the 4 charges that would be brought against the defendants. The first charge, war crimes, covered long-established offences as outlined in the Geneva Conventions, such as the mistreatment of POWs or the targeting of civilian populations.
There had been, for centuries, doctrine and practice of understanding what the laws of war were. What can you and what can you not do in waging the war? And so those laws and customs were embedded in a lot of military practice, court-martials at national levels, etc.
Although war crimes was a well-established concept at the time of Nuremberg, the Allies were determined to hold the German leadership to account for the horrors committed by the German government throughout Europe and against their own citizens. This new charge was crimes against humanity.
Crimes against humanity consisted of what today we would call atrocity crimes. Murder, enslavement, torture, persecution, all those kinds of things were lumped under crimes against humanity.
But the third charge was the most radical. For the first time in history, the tribunal set out to outlaw all wars of aggression. This charge was called crimes against peace.
That was a dramatic transformation in trying to turn what had been a prerogative of sovereign states into, in a sense, the centerpiece of this international trial.
As Jackson said, if we can cultivate in the world the idea that aggressive war-making is the way to the prisoner's dock rather than to honors, we will have accomplished something to make the peace more secure. On the matter of how the trial should be run, the Allies were completely divided.
You had the American and British teams that are used to a kind of Anglo-American common law system. You have a French team that is more associated with a continental legal system.
But it was the Soviets, whose system and concept of justice was the most unique, who raised the most powerful objections.
The Soviet theory of a criminal trial in general, and particularly of a criminal trial with heightened political significance, is that the guilt of the defendants is established before the trial starts. If you weren't guilty, we wouldn't be putting you on trial. The goal of the trial is not to decide whether or not you're guilty, but to demonstrate to the world that you are guilty.
And so getting these, different bedfellows together and to agree on a basic architecture of how the trial should run was really a tricky thing. And I think Robert Jackson was prepared to scuttle the entire trial if the Soviets didn't understand that this was a forum for proving guilt, not for showcasing guilt.
In the spirit of post-war cooperation, the Soviets agreed to compromise. The International Military Tribunal now had a legal foundation upon which to build. It now also needed a home. And in bombed-out Germany, intact courthouses were in short supply.
You simply cannot overstate the degree to which Europe in general and Germany in particular were devastated. There's just rubble everywhere. There's very little infrastructure.
The medieval city of Nuremberg was chosen partly because its palace of justice was mostly intact, but also because of the city's symbolic significance to Nazism. But turning a devastated city into a suitable location for a major international tribunal posed an enormous logistical challenge.
Even 12 months afterwards, people were reporting in letters back home that they could smell corpses underneath the rubble. Could you imagine?
Nuremberg was located in the American zone of occupation. But even the cashed-up US struggled to provide the water, food, fuel, accommodation, and equipment necessary.
So I think one thing we need to appreciate is what an incredible logistical feat mounting the trial was. This is a trial that starts in November 1945, scant months after the German defeat. Basically, the Allied teams had to sift through tens, if not hundreds of thousands of documents for the purposes of, again, proving, not showcasing the guilt of the accused.
The trial would require huge resources. The prosecution would need to examine over 100,000 documents, entering 4,600 of them into evidence, along with 25,000 photographs and kilometers of film. All this material needed to be brought to Nuremberg, translated into English, French, and Russian, copied and shared with the prosecution, the defense, and the press. In war-ravaged Europe, it was not immediately clear that there would even be enough paper available. Another challenge was finding the hundreds of technicians and specialists qualified to carry out the work.
They need translators who can read the German and translate it into not one, but eventually 3 languages, and who had technical abilities. So in London, where the seized Navy records were of the German Army, there were a group of women known as Wrens, the Women's Royal Naval Service, who had been tracking U-boats throughout the war. And they were German speakers, and they also had some technical ability to understand what some of the terminology meant.
As preparations for the trial got underway, the world's press began to arrive en masse. Nuremberg was big news. Among the press corps were individuals who would go on to become household names, such as legendary journalists Walter Cronkite and Dame Rebecca West, as well as future West German Chancellor Willy Brandt. Many were housed at a confiscated castle formerly owned by the Faber-Castell family, leading the press corps to be jokingly referred to as Faber's flock. The press, as well as the tribunal itself, realized that whether it succeeded or failed, the trial at Nuremberg would go down in history. And what the press and the public were clamoring to see were the men standing trial, the Nazi leadership.
This was the scene at Flensburg after the arrest of the so-called German government. It was a day of mass arrests amounting to between 5,000 and 6,000 Germans. These included at least 300 high-ranking officers and 40 important civilian officials, as well as all the small fry.
One of the problems facing the Allies as they're making decisions about who to put on trial is that many of the most important political leaders of the Third Reich are dead. Who's left? Who can we put on trial to represent the top dogs, if you will, of the Nazi regime, given that some of the most obvious candidates aren't available?
From the thousands of German prisoners, the Allies selected a group that was large enough to be representative, but small enough to make for a manageable trial.
The strategy was to find the ones most responsible, and most responsible on a political level, on a military level, but also on economic levels and with regard to German industries.
The Allies chose 24 politicians, bureaucrats, and senior officers as representative of the various elements of the Nazi machine. Of these, only 21 would face trial. Martin Bormann, unbeknownst to the tribunal, had been killed during the war and would be tried in absentia. Charges against Gustav Krupp, the aging owner of the arms manufacturer Krupp Industries, were dropped for medical reasons.
He turns out to have dementia, and so they have to drop the case against him before the trial starts.
Another of the accused, Robert Ley, chief of the German Labour Front, was obsessed with becoming a martyr for the Nazi cause. He killed himself in his cell a month before the trial began. The 21 accused who did make it to trial were an eclectic group. Politicians and propagandists, senior ministers and military officers, members of the SS, and economists. But the chief defendant was one of the most senior Nazi leaders, Hermann Göring.
Hermann Göring, he's a very prominent member of the Nazi Party. He's also a very prominent member of the German state. Indeed, he could also be lumped in among the military defendants because he's also chief of the German Air Force.
By bringing this cross-section of the Nazi leadership to trial, the prosecution was sending a deliberate message.
So it's the attempt to present to the German public, to the American public, to the Russian public, that the German National Socialist system was sort of in every layer of government, military, and even in the society when we talk about money and industries. National Socialism was all-encompassing the German people.
Adolf Hitler, Heil!
The challenge the prosecution faced was proving the guilt of men who were often insulated from the crimes of which they were accused. To this end, the US delegation had added a fourth charge to the Nuremberg Charter, something new to international law.
The defendants were charged with, we can say, 3 substantive crimes: crimes against peace, war crimes, crimes against humanity. But the prosecution also charged them basically with what we could almost describe as an organizational offense, namely conspiracy.
The prosecution would seek to prove that each of the accused had played a part in a greater Nazi conspiracy.
The basic idea is that whenever two or more people get together to plan and carry out a crime, every participant is equally guilty of that crime.
You could be held liable for conspiring to torture somebody, even if you did not lay a hand on the person. Even if you were in Berlin and the act occurred countries away from there, but somehow something you did as a leader set in motion that particular criminality. Illegal invasion of Poland and all these other countries, the slave labor that occurred in the camps. You could be held to have conspired to be part of a common plan to do that, even if you weren't on the scene.
Drawing on the FBI's experience prosecuting mobsters, the US contingent felt that the Nazi regime represented a textbook criminal conspiracy.
It was basically the idea that comes from the prosecution of organized crime in the United States, was the way to kind of overcome the problem of having such a large group of defendants, some of whom did not have a lot of contact with each other, was basically to say, well, they were all part of some larger criminal enterprise. And so all we need to prove is that they shared the goals of this larger criminal enterprise.
So you can see why that would be a really appealing way of trying to get at any kind of organized criminality. And so it's very useful for prosecuting state actions.
To succeed, the Nuremberg trial would have to not only secure convictions, but prove its moral and legal legitimacy. And the world was watching.
It's 10 o'clock on the first day, and everyone in court stands up as the tribunal enters. 4 judges and alternate members: French, American, British, and Russian.
In the spirit of cooperation, each nation provided one judge. Britain's measured and calm Sir Geoffrey Lawrence, who also acted as the tribunal's president. Joining him was former US Attorney General Francis Biddle. The Soviet representative was Major General Yona Nikitchenko. Unfamiliar with the legal system employed at Nuremberg, Nikitchenko had overseen Soviet show trials in the 1930s, such as that of Stalin's political rival, Grigory Zinoviev. Henri Donnedieu de Vabre, the French choice, had never served as a judge. France's senior judges were compelled to swear an oath to the pro-Nazi Vichy regime. De Vabre, despite his inexperience as a judge, at least had a clean record. Each defendant had been able to choose their own German defense attorney from a shortlist provided by the Allies. But many lawyers refused to take the case. This left many of the defendants without counsel for months while they were in captivity. Some of the judges were shocked, as this would have been grounds for mistrial under the US legal system. On the 20th of November 1945, the press gallery in courtroom 600 of the Nuremberg Palace of Justice was packed. They had gathered to hear the reading of the indictment. The Nuremberg trial was now underway. Each defendant was called upon in turn to enter a plea.
You must plead guilty or not guilty.
All pleaded not guilty.
Bekenne mich im Sinne der Anklage nicht schuldig.
Nein.
Ich bekenne mich im Sinne der Anklage für nicht schuldig.
The trial was very much structured according to a US, American, and also British procedural structure. So the prosecutors would start and present their cases, and they would go one on one through all the accused.
The prosecution teams recognized that given the enormity of the work before them, they had to coordinate their efforts.
The privilege of opening the first trial in history for crimes against the peace of the world imposes a grave responsibility.
There's a lot of defendants, there's a lot of evidence, we need to organize this. We've got 4 different countries doing the prosecution, and they decide basically that each country will take some segment of these charges, and it's actually the Soviets who come up with the basic plan.
The Soviets proposed dividing the charges up between each national contingent. The British would be responsible for prosecuting crimes against peace. The French would handle cases of war crimes and crimes against humanity that occurred in Western Europe, while the Soviets prosecuted the same crimes committed in Eastern Europe. As well as prosecuting crimes against peace, it would be the US delegation's responsibility to prove that the Nazi regime was actually a criminal conspiracy.
The Nuremberg trial is like a serial story, with pages of particular interest in every chapter. When the chart of the Nazi organization was displayed in court, for example, it evoked great interest from everybody present.
The American prosecutors faced an uphill battle. They sought to prove the existence of a coordinated Nazi conspiracy to wage war and commit genocide. Often, the documentary evidence suggested that Nazi policy-making was simply not that coherent. It was unclear how a conspiracy could be proven. Could, for instance, Hitler's speeches serve as concrete, unambiguous evidence of intent? Did it necessarily implicate those in the dock at Nuremberg?
First, a brief reference to the history of the Nazi Party. The court will no doubt recollect that the National Socialist Party had its origin in the German...
While Jackson and his team persisted in building a conspiracy case, many of their colleagues viewed it with suspicion.
That was among the more controversial aspects of Nuremberg for a couple of reasons. One was in what we call civil law countries, including France, Germany, Italy, etc., then and now did not accept conspiracy as a crime. And so the concept seemed alien to them. Beyond that, conspiracy is not uncontroversial in common law countries either.
The other problem with that is this idea that everybody involved in a crime is sort of equally culpable. If I'm the dictator and I order people to murder someone and they shoot that person, does it actually really make sense to say that they bear exactly the same responsibility that I bear, even though I'm the head of state? And so this idea that all participants are equally guilty makes sense because it is organized criminality, but it also then risks blurring distinctions between people who initiate action and people who merely implement action.
And what of Nazi propagandist Julius Streicher?
He was the editor of this magazine called Der Stürmer, and that was an incredible sort of anti-Semitic magazine that would really incense hatred towards the Jewish race and being extremely keen on transporting conspiracy theories with the Jewish idea and the Jewish money and whatever. Horrible, horrible paper.
Jackson pointed to his publication as evidence of a broader Nazi conspiracy. But by the start of the war, Streicher had no official role in the Nazi Party. While he incited hate and advocated for war, could he really be considered part of a criminal conspiracy? The British team, meanwhile, were focused on building a case of crimes against peace. Here, they faced their own problems.
to prove that Germany invaded Poland and then also invaded the Benelux states and France and then Russia, that was quite straightforward. What was questioned, however, was whether it was legitimate to have the crime in the first place.
The charge of crimes against peace was something new. Crucially, it had not existed at the start of the war.
There's this kind of wonderful Latin phrase, nullum crimen sine lege, which means no crime without law. Basically meaning it's fundamentally unfair to try someone for conduct which was not criminal at the time it was engaged in.
Although the right for nations to declare war had long been accepted, at Nuremberg, a greater principle of justice was recognized. Individuals could be held responsible not just for declaring aggressive war, but also for the way that war is conducted.
Effectively, what the court said was that the underlying crimes were indefensible. Everyone knew that you couldn't invade countries without some sort of justification, self-defense, etc., at the time that Hitler started doing it. Everyone knew that you couldn't torture people, that you couldn't massacre civilians, you couldn't enslave civilians. And they ought to know that they one day may be brought before a court and have to answer for violating these rules.
Britain's chief prosecutor at Nuremberg, Sir Hartley Shawcross, said, "It is a fundamental part of these proceedings to establish for all time that international law has the power to declare that a war is criminal." Slowly, the British and Americans built their case. But this alone would not be enough. The prosecution wanted to not only win convictions, but to shape the public's understanding of Nazism. For this, the press corps would be crucial. But reporting on hard legal theory and the tedium of procedure was failing to create headlines. This was particularly true in Germany, as most of the population was too preoccupied with the struggle of rebuilding to pay attention. Early on, the US and British prosecutions decided not to rely on eyewitness testimony as the cornerstone of their cases, preferring instead to lean on documentary evidence, which would be harder for the defense to refute.
It was very powerful evidence to say, how do you deny that this is your signature and that you made this order? But one of the unfortunate consequences was that a lot of the trial time was then devoted to reading documents into the trial record.
This did not make for the exciting trial that many had hoped for. For everyone involved, the Nuremberg trial became a hard slog, which was only exacerbated by a very practical issue.
The people in the room don't all speak the same language, and so there's just a technical, logistical issue of how do we communicate with each other, but there's also a principle of fairness. And the simultaneous translation system is at least part an attempt to demonstrate that fairness.
Free of charge, the computer company IBM offered up a new system which allowed 36 interpreters working in shifts to simultaneously translate what was being said into 3 other languages.
Посредством инцидента в Чехословакии.
Without this system, it is estimated that the trial could have lasted 4 times as long. Even still, the limitations of the technology meant that the speed at which evidence could be entered into the record was only 60 words per minute. A flashing yellow light would indicate to the speaker if they were speaking too quickly, and a red light if they needed to repeat themselves.
They literally read translations of documents into evidence. one after another after another. The tedium affected everybody over time. The judges, the lawyers themselves who had to stand there and read these things. The media were bored to tears and looking for something to put in the paper.
Day after day, the defendants were led from their heavily guarded prison next door into courtroom 600 of the Palace of Justice, where they listened as documents were read into the court record, painstakingly building a case against the accused, dryly cataloguing the crimes and atrocities of the Third Reich and its servants.
And that turned a trial that was meant to be this kind of spectacular proceeding into something of a little bit of a dreary affair, such that you have this very famous British writer and journalist, Dame Rebecca West, describing Nuremberg as a citadel of boredom.
The tribunal was in grave danger of losing the world's attention. But when it was the French and Russians' turn to present their cases, things began to change. While the US and British teams focused mostly on documents, the French and Russians were more willing to use witness testimony.
Reisman Samuel.
They understood it was important to introduce a human element into proceedings for the benefit of the media and the judges. Especially as their purviews, crimes against humanity and war crimes, were much more tightly bound to the human tragedies of the Second World War.
Everyone sort of sat up and started paying attention, but there were some concerns about reliability. How do you cross-examine somebody who says this happened in a camp 3 years ago? There was certainly a sensitivity among the judges and even the defense counsel of the fragility of some of the witnesses, so many of them went unexamined.
But the ones who did take the stand made a strong impression. Marie-Claude Vaillant-Couturier had been a member of the French resistance. She spent time at the Auschwitz-Birkenau extermination camp, as well as the Ravensbrück camp, where she contracted typhus and almost died. During her testimony, she described, in great detail, heart-rending scenes as hundreds of thousands of people were marched into the gas chambers, as well as her own brush with death through disease.
Elle est morte au bout de 15 jours à Auschwitz.
Quite ill-advisedly, the German defense attorney stood up and cross-examined her and said, "You look pretty healthy now. How do you explain how healthy you look when you say all these bad things happened to you?" And let's just say he didn't win the end of that argument.
À Auschwitz, visiblement, le but était l'extermination.
Calmly recounting her recuperation from typhus following her liberation, Vaillant-Couturier outlined that of the 230 with her when rescued, she was one of only 49 who survived. Seeing the power and the moral weight of eyewitness testimony, the US changed their approach.
American prosecutors pretty quickly realized that this trial by document, that they were kind of losing their audience.
These are the locations of the largest concentration and prison camps maintained throughout Germany and occupied Europe under the Nazi regime. This film report illustrates the general conditions which prevailed.
They almost kind of just interrupted their presentation to bring in, to screen a documentary film in the courtroom. And it really is a kind of unprecedented use of documentary film in a criminal trial setting.
The documentary, compiled by the US Signal Corps, presented the footage of the liberated concentration camps in the West.
Former inmates demonstrate how they were tortured by the Nazis. Other evidences of horror, brutality, and human indecency are shown, and these people are compelled to see what their own government had perpetrated.
Depicting a tiny portion of the camps in which the Nazis' industrialized slaughter murdered some 6 million European Jews, 3 million Soviet prisoners of war, 2 million Poles, and hundreds of thousands of other marginalized groups was on display for all to see. Many in the courtroom had never seen anything like it.
Horrible images of the corpses, this mass of corpses that were found, and the way the inmates looked when they were liberated, totally, only skin and bones. Really horrible pictures.
They were camps such as Dachau, Bergen-Belsen, Buchenwald, and it really did have a galvanizing effect on the trial.
This was the first time film footage had been used as evidence in an international trial.
And there are many reports of people simply leaving the room and throwing up before they could get out. It was extremely unsettling to people. The effect of the films was so great that in almost every memoir, that's one of the days that's always mentioned.
It wasn't simply the reporters or the spectators in the courtroom who were shocked, but even the defendants themselves recoiled when confronted with such stark images of the reality of the conduct they had condoned or approved of or organized.
The combined effect of the Russian and US films did enormous damage to the defendants. The Allies had set out to demonstrate to the world the moral weight of this new international court. And as the prosecution drew to a close, they had succeeded. As one of the court's officials, Eri Neve, said, "Those ghastly piles of naked moon-white corpses at Belsen and Dachau would not soon be forgotten. At Nuremberg, they were with us always."
In 8 months, a short time as state trials go, we have introduced evidence which embraces as vast and varied a panorama of events as has ever been compressed within the framework of a litigation.
In March 1946, the prosecution rested their case. The narrative they had presented had recaptured the world's attention. The tribunal had claimed its legitimacy and would go on to frame how the crimes of the Nazis would be remembered.
Which will live as the historical text of the 20th century's shame and depravity.
But it did much more than this. The prosecution's case asserted for the first time that any individual, no matter how powerful, could be held accountable for the worst of crimes.
That's revolutionary. And so in a strange sort of way, the Nuremberg precedent opens the door to what we call human rights today. Because if humans could be executed for violating international law, then they could also be protected from crimes and violations of human rights.
In the space of a few months, a new system of laws had been articulated. The prosecution, led by Jackson and based on cold, hard evidence, had been damning. As Jackson said in July 1946, in a speech as powerful and resonant as his opening remarks, "If you were to say of these men that they are not guilty, it would be as true to say there has been no war, there are no slain, there has been no crime." But would it be enough to see each of the 21 defendants convicted? Or would some of these Nazis walk free? It was now the turn of the accused to present their defense and face cross-examination. This was their last chance to escape the gallows.